Welcome to our panel named Japan's Act on Protection of Personal Information, Triennial Review and Current Status of AI Regulation. My name is Yasutaka Machimura. I am a professor of civil procedure in Japan, Seijo University. But now, a visiting researcher at the University of Poitiers in France. And my research interests are current consumer law and cyber law. The purpose of this panel is to provide an overview of current situation about the Personal Information Protection Act in Japan and AI legislation in Japan. Also, about these topics, we'd like to engage in discussion with our European colleagues. Unfortunately, information from Japan is rarely available in English, and even government publications tend to huge and heavily edited publication, but only in Japanese. That's why we've invited experts in this field to offer independent commentary on the legislative proposal and amendment bills currently under review. We are pleased to welcome Professor Laura Dressler, who has in-depth knowledge of data transfer between Japan and the EU, as well as a strong understanding of Japanese legal context. She will lead a session by posing candid questions and raising key issues. In this session, we will begin with two reporters from Japanese experts, each lasting about 15 minutes. And first, Mr. Yoichiro Itakura will present a clear and concise overview of 3 years review of Japan's Act on Protection of Personal Information. I expect concise size. Normally, he treats many huge information. His explanation will be tailored to help European participants understand the current development. Japan's Personal Information Protection Act underwent significant revisions in 2021, influenced by the Brussels effect, also to integrate the private and public sector. Now, 4 years later, Mr. Itakura, one of the most knowledgeable legal scholars in this area, will explain the status of ongoing revisions. Next, it's a part of Professor Akemi Yokota. We will discuss Japan's proposed AI litigation. This bill, AI legislation, not a litigation. This bill has already passed the lower house and is currently under deliberation in the upper house. It is expected to be enacted soon. Professor Akemi Yokota is a specialist in administrative law and a leading expert on the intersection of administrative and AI law in Japan, since she was a guest researcher at Mainz University in Germany. She will guide us through this topic because of her significant experience of discussion on AI regulation in public administration. According to her, Japan's approach to AI regulation differs significantly from international trends. While Japan has favored a soft law approach so far, this new bill may signal a shift. But is it truly a move toward stricter regulation? I don't know. Since the Japanese government has only published an interim English report on this legislation, Professor Yokota will provide important context and analysis to help us understand the bill's true intent. Following the reporter, Professor Dressler will explain her opinion about Japanese law in comparison to EU or other countries. Her commentary on this legislative development from the perspective of EU law will be so interesting, I think. Afterward, we will open the floor for question and discussion. And we encourage everyone to actively participate in the Q&A session. So, first presenter Yoichiro, go ahead, please.
Thank you for coming to the last and very rare panel of Japan. So, please.
This is my slide. His slide is another.
Sorry.
Okay.
Yes, that's right. Thank you. I will introduce second Triennial Review of Japanese APPI, and this slide can be gotten by this QR code. So please scan your camera this QR code. You can get PDF version of this slide. Okay. Okay. I'm the Japanese lawyer in the area of data protection and the cyber law, Hikari Sogo Law offices in Tokyo. And I will introduce Japanese Data Protection Act and the current status of Triennial Review of Japanese Act. This is a very overview of Japanese data protection legislation. The name of the act is the Act on the Protection of Personal Information. It's sometimes said as APPI. It contains the regulation for private and public sectors. It has some governmental ordinances, regulations, and many kind of guidelines. And some business sector has their own guidelines. It's not by public and their own guidelines. And we have some gradual discipline of personal information, personal data, and retained personal data. It's the difference from GDPR. GDPR has only this discipline of personal data, but the Japanese Act has a gradual discipline. And we also regulate private sector, it is said, and business handling personal information. So GDPR has controller and processor, but Japanese Act has such kind of discipline. And the Data Protection Authority in Japan is Personal Information Protection Commission. It is said as PIPC or PPC. And Japan is the one of the country of Apex CBPR system, and EU or UK to grant adequate decision to Japan in now in only for the private sector. And the Act has a so-called Triennial Review System. It's very rare in the data protection area in the world. The PPC has the obligation to review the Act in every triennial, during 3 years. Renewed every 3 years after entry into force. So in fact, about 5 years, after 5 years, they will review the Act. So, and what is references to AI in this Act? In current status, before the second triennial review, it does not have direct provision in legislation, and there's no AI-specific guidelines. In some countries, there are some AI-specific guidelines. For example, Singapore has AI-specific guidelines, but Japan does not have AI-specific guidelines. And we have some information in the Q&A from PPC. And this is a very overview for data protection and AI legislation in Japan, compared with Europe, GDPR. In data protection legislation in Japan, we have APPI, and in AI legislation, the Akemi will introduce AI bill. It's just now in our diet, and in Europe, of course, you have GDPR in data protection area and AI Act in AI legislation. Triennial review system. This is a history of APPI amendment. In 2003, we established the Act. And in 2015, we established the PIPC as a privacy commission for only private sector, and the triennial review system started. In 2020, first triennial review, we introduced strict international transfer, data breach notification, and other system. And the next year, 2021, we reviewed omnibus legislation, our Act, and the expansion of PIPC jurisdiction. In this year, PIPC has a jurisdiction for public sector. And from 2024, we started second triennial review in PIPC meetings. Second so-called triennial review, and PIPC published some papers. They are in English, but they have only Japanese version. From June to 2024, they have published 3 papers for triennial review. And this is an overview of second triennial review. This is unofficial and very private translation, so do not tell about this slide to PIPC. And there are many topics for second triennial review. For example, statistical purposes use will be exemptions for use. This is very, this has great concern to the AI area. And we will introduce some kind of contract use for like GDPR Article 6, B1B, and also the data breach notification to data subject and to PPC will be, it's very strict now, so we will have some kind of exemption. And we also have some plan to introduce children data regulation. And also in the personal data risk management area, we will have some kind of controller-processor relationship clauses. And also in biometric or facial recognition data, we will have some regulation. This is a very overview of second triennial review just now. And from this time, I will introduce some topics related to AI area. And statistical purposes, including AI models use, will be the use for AI-related area. It has two technological implementations. One is machine learning from internet crawling for AI models. To make some AI models, we will crawl a lot of internet pages. But when the sensitive data is included in the page, it is prohibited to get some page without consent. So the statistical exemption will allow to get pages from internet when it includes sensitive data. And when you use some secure multi-party computation or TEE, you can connect to body's personal data for make some statistics. So this is a figure for these two technical area. One is learning from internet. When the pages include sensitive data, you can get internet pages for make statistics or statistics-like AI models. And the second is the secure multi-party computation exemption. Next is children data regulation. We will introduce additional requirements for handling of children data. We don't have any specific regulation for children data, but maybe in next review, we will have some requirements for use children data. Transparency obligation or consent obligation, not only for children, but also for parents, the controller will need. And in personal data risk management area, we will have some new relationship between controller and processor. In Japan, processor is said as entrusted person, so the name of the processor is different in our act. But maybe also in the EU, and the controller and processor relation is a very difficult question. When the processor is AI provider or a cloud service provider, because controller have to control processor, but when they are AI service provider or cloud service provider, it's very difficult to control, of course. They are very big, and when we use some cloud services, we just use cloud services for terms of use, how to control them. This is a controller and processor relationship. And in APPI, Japanese APPI Article 25, the necessary and adequate supervision is needed. But when the processor is Google or some kind of AI provider, we can't, actually we can't supervise them. And some AI service is built with AI API, so the sub-processor is AI model provider. How to supervision them? It's a very difficult question. And in effective compliance area, we will introduce some kind of recommendations or orders power to PPC to third parties. And it's, for example, when controller has some problem for the compliance with our act, PIPC, of course, will order for action to stop such kind of illegal, but they will have some power to order for action to the third party, for example, search engine provider, to delete such results for the website of the illegal controller. And this is a very new concept in Japanese Act. And the last, we will introduce, PPC wants to introduce administrative fines in our Act. We don't have any administrative fines power in our Act to PPC, Privacy Commission. But administrative fines seems to be very necessary for regulate big techs. So the PPC wants to introduce administrative fines, but businesses does not want to. So this is a great struggle point of our review. And also, Japan is also the country use U.S. big tech companies and big U.S. big AI model companies. So the problem for the overseas administrative fine is a great problem. This is now the great overview of second triennial review in Japan related to AI area. Thank you.
Thank you. Thank you, Yojiro. Next speaker is Yokota, Akemi Yokota. Please, go ahead.
Hi. Change the slide, please. Hi, my name is Akemi Yokota. I also have a QR code because my slide is a little bit long. Then I also have longer version and short version. So please access I'll do the short version. Then during you check the QR code, I want to introduce myself. My major is administrative law, public law, environmental law, and information law. How huge am I? Because I'm curious about everything, the new thing. Then I was a visiting scholar in the Germany, Mainz University. Then nowadays I'm a member of the study group, Ministry Internal Affairs and Communications, especially for the committee impact of the risk assessment of the AI network society. And nowadays I do 2 working groups join AI utilization in local government and study group on AI utilization from the perspective of administrative general law. But actually we don't today, we want to consider to the Japanese AI legislation itself. Then, as Yoichiro said, nowadays we have the bill for AI law, so-called AI law, but actually it is not AI law, but AI promotion law. So I want to explain about this situation. All right? So let's move to the slide. Okay. Then. I will have 2 slides for overview, first of all. Then there is currently no equivalent to the AI Act as is in Europe side. Then nowadays we have the soft laws. Soft laws for AI society is two type of the Japanese society. One type is a very huge principle for human-centered AI society. You know that maybe the international principle because Japanese governments tend to show the image of the AI governance. Then it is also has another version of the guidelines. This is domestic version. Minister of Internal Affairs and Communication and Minister of Economy, Trade and Industry combined many guidelines into one guidelines. It is guidelines for AI operators. Then another, we also know the many guidelines about specific areas. This is the current situation with Japanese AI governance. Then, Road to AI Law Bill is also an overview. There is a AI Strategy Council. This council is connected to the ministry levels and the specialist levels and so on. Then they had a meeting for the approach to AI institution compliance. This is the last year. Then, unfortunately, this document is only in Japanese, but it is important. I think this document is very important, so I will explain about it. Then, this meeting also made a subgroup of AI Institutional Study Group. Then, this study subgroup and the AI Strategy Council show the internal summary in this window. Then this is a step for the AI law bill in Japan. So we have to consider about so-called AI law bill. The actual name is Act on Promotion of Research, Development, and Use of Artificial Intelligence-related Technologies. Japanese government and Japanese newspapers shorten this is Japanese AI law, but actually, please look at the name. Promotion of research and development use. There is no connection to the principle, actually. So I will explain about it. Then we have to consider about why Japanese government choose the software approach. It is not only for the AI strategy, but for everything. In Japanese culture, in Japanese legal culture is highly connected to software approach. There are two tendencies by the citizen side and the governmental side. Tendency of Japanese citizens and companies is citizens tend to follow the announcement from the government, even they are not legal bindings. So Japanese government say advice and guidance during the corona pandemic. Everybody follows the guidance. It's good to follow, so it's very good. But sometimes we have to consider about the dark side of this kind of issues. One thing is reputational damage. So Japanese citizens think about if some company don't follow the Japanese guidance, government guidance, they think, this is evil. So reputation damage is very high in Japan, especially against the guidance from the government. It is also the fear of being disadvantaged by the government. It is not legal binding, but they are fear about against the Japanese government. They are fear about the reputation, and fear about the other risk of the influence of the governance side and so on. So this is how tendency of the Japanese citizen and company side. Then this is also the government side tendency to avoid legal binding power, avoid administrative orders because of the with high enforcement costs. They are afraid of mistake, so that's why they do please return slides before. Then they with high enforcement. So even response to the coronaviruses, Japan has overused the software approach. Then move to this slide. And so there is many discussion on regulation in these individual sectors, but they made many guidelines. Then, so my colleagues, Professor Habuka, makes these features a sector-specific and software-based approach. Announcement and guidelines without legal binding force, but they actually so-called AI governance, AI guidelines, and so on. Then Japanese society followed the guidance. Then, but a little different from the AI bills, so change in the AI strategy, connecting the hurdle, I want to explain some change. AI Strategy Council in Japanese, so AI Senryaku Kaigi, this is held in cabinet office, very highly political power and compromise experts. Experts comes from academic in technology, law and society, and company involved in AI development in private sector. and relevant ministers from the government side. So it's very highly high level of the council. Then they made papers for the approach to AI institution, so institution. Then this paper showed significance of soft law and the concept of hard law application. This is the first time to Japanese government say about the hard law approach, but it is combined with the soft law and hard law. Then here is only in Japanese, actually, risk-based approach, existing legal system, and soft law. But it is hard to understand, so I will make a unofficial, unofficial, but I will explain this moment. Then they said there is a high impact, high risk position, and low impact, low risk position. They also divide AI developer, AI provider and users, and provider section. The provider section means that it's kind of the, it's kind of the platform, online platform operators, and it's content moderation. So a little different from the issues. But for the AI developers, AI provider and user session, it's very important. Of course, sure, low impact and low risk point, there is only the risk management problem. So this is good for soft law approach. So disclosure, compliance with rules, and formulation, public, and so on. But we have to consider about high impact, high risk problem with AI developer and AI provider users. So you can see the number one and number three, this is a point of the regulation problem. Then it is also another point of the number 5 is approximate procurement and use AI by the government. This is the first time to say the Japanese government say about governmental use AI program. So this is a conceptual framework of the Japanese government think about the AI program. But AI bill only sees some of them. So please keep in mind this framework. Then these details in conceptual framework about 2 areas. About one, AI developers high risk, high impact area is they say that recognize the necessary the legal system to supplement the soft law. So this is combined hard law approach and soft law approach, such as business operator guideline from the perspective of public safety and security. This is the very important point of these issues. Then next is about the AI provided user side high risk problem is classified based on whether industrial specific law is actually exists or not. So they are very slowly step into the regulation, but they consider about usual regulation for the consumers, for the operators, and so on. Then they want to connect to the existing regulation. If there is no existing rule, this is considered about the next stage, but they are slowly to step in to this kind of issue. Then AI Strategy Council and AI Institute Study Group makes next step is the internal report. You can see this internal report in English also, so please check it out. Then I want to consist on the soft law approach and the hard law approach. Then there is a paragraph about application of law and making use of soft law. Then they said the final session is regulation by law should be limited to case where voluntary effort by business operator cannot be expected. So this is a very slowly approach, but they show the image of the connecting to the soft law approach and hard law approach. Then they say that individual law and regulation already exist, only where truly necessary or clear role division and technological neutrality and minimize comparison burden and so on. So they are very take care about the business opportunity, not too much regulation, not to avoid too much regulation. Then this is connected to Japanese AI law bill. As I said, commonly known as AI law, but its official name is the promotion bill. So I want to say this bill as a AI promotion law bill, I want to say, but you commonly say AI law bills. So this is also criticized by the Japanese newspaper, Nikkei Asia. Ryotaro Sato says, however, this does not impose binding requirements, making it possible largely to a symbolic act. I agree, totally agree with him. This is symbolic act nowadays. Then we can see at a glance the AI law bill in Japan. Then the name is the cabinet. This bill comes from the cabinet side. Act on promotion, research, development, application, table of contents, please check it. Chapter 1 is general provision. Chapter 2, basic policies. Chapter 3, basic plan for artificial intelligence. Chapter 4 is artificial intelligence strategy headquarters. So that means the main issue in AI law bill is important point to make a law, necessary to making a new law is 3 points. One bullet point is establishment of AI strategy headquarters. This is a headquarters for AI strategy. It is important because there is no specific organ in Japanese side, so this is a very important point. Then next bullet is a basic plan. This is also just a plan, but for the legal binding force to against the Japanese government. So Japanese government must make the basic plan. It's very important. Then another thing is legal qualification of information gathering and advisory function by the government. Advisory function by the government. I see this. There is no order. There is also provision regarding following Article 3 basic concept in general side. But there is no direct link between the basic concept and the principle that Japan has demonstrated as an international committee thus far. So there is only for the promotion law, so that's why there is no connection with fundamental rights and fundamental issues and so on. Then let's check the issues. Then Japanese government usually says that there is a research and studies article. Article 16 has blah, blah, blah. A little bit too long. But the end of the session, end of the article is very important, so let's move to the in details. National government shall take necessary measures, including providing guidance, advice, and information to research and development institutions, utilization operations, and other relevant parties. This is necessary measures usually Japanese government claimed about these bills. But for my specialty, administrative law view, this provision does not include mandatory enforcement powers, just advice. It appears that Japanese government believes that public disclosure of situation may serve as an alternative to regulation, but actually there is no binding powers. They can do the guidance. But in Japan, the soft law approach is very strong. So Japanese government have to develop their power to collect the information, to show the public to the information. It is important. So this is the measures. Then my short summary is here. perception of Japan's current situation. While discussing on AI regulation has been progressing in many countries around the world, Japanese take a strong soft law approach in AI regulation, as I said. Then the new AI bill, in terms of its effectiveness, will only have a symbolic effect nowadays, and will not significantly change the situation. But it is the first step to make a new bills, new act in Japan. It's a very big step, I think. But actually, there is no binding powers. I want to add my research question, because in Japan, has been almost no progress in discussion on the use of AI within the government. It is a very important point, but today we don't have enough time to explain about it. So I want to sum my opinion about it. We have to consider not only the guideline for the AI government side, but for the AI government use law inside Japan, I think. But slightly, I interviewed many Japanese government side. They are hesitant to make some rules, but some officers have trouble with how to use the generative AI or more AI technology. So I want to make discuss about this problem with many of you colleagues in international side. This is my opinion. Guidelines is not enough, not only for the business side, but for the government side. So I want to be moreover, want to do. So keep in touch. This is my presentation. Thank you.
Thank you, Akemi. So finally, the comparison with in European law and European legal culture and Japanese legal culture, I expect. Please go ahead.
Yes, so I will keep this brief because I also don't want to rob the audience from the opportunity to actually ask our Japanese experts about the different laws there, because as was said in the introduction, we don't get this chance very often that we hear about how they regulate things there. But some points also reacting to things that have been mentioned in the presentation. I think one thing I always find when I now look at the data protection side very notable is how often they review their own law. I mean, we just this week have finally published, or we have published something that might review the GDPR, but there it's really very regularly, which is sometimes a bit annoying because I'm trying to write a chapter on Japanese data protection law and I have to constantly update it. But I think it's actually maybe a good practice to very regularly review the law and don't be afraid to adapt it to increase protection. I think that has to be also clear. The goal cannot be to lower it, but really to make sure it's more clear. And I think you can see in the Japanese situation that that is the goal, because a lot of the things that we, in 2019, when the adequacy decision for Japan was adopted, put into an extra document called the supplementary measures to make sure there is an adequate system. These things have been now taken up into the APPI, almost all of them. So I think that's a remarkable thing for Japan to do, that they really reform the law and are trying to make it more protective. But what's also really worth highlighting is that originally, so when the adequacy decision was made, the Japanese data protection law only applied to the private sector, and the public sector had their own maze of rules on different levels, and now it's all in one law. So really, there is the Brussels effect. If it ever existed anywhere, I think we can see it here. However, when we now look at data protection law in relation to AI, one thing that was noted back then and is still notable now, there's no concept like profiling automated decision-making that we would have, for example, in GDPR in Europe. So that's not considered specific in any provision. The other provisions, of course, apply, but we don't have this very specific protection like we have in the GDPR, and where we now see, I mean, for a long time I was also skeptic if that is useful in any way or form, but now we have case law like Schufa, done in Bradstreet, so we see it as actually does add a layer, it gives transparency to people, so it is maybe something that future reforms might also introduce, but I'm curious to also hear about the experts, what they think if that could happen or not. What I find interesting about the changes that are now proposed is especially this idea that we're gonna exempt statistical purposes in order to make sure AI systems can scrape and train themselves, because that is a big issue in Europe. But here we are still discussing if an AI model is personal data. I think it's fascinating that kind of by making it explicit in the new law, you admit that right now this is not possible. So you could not, under the current APPI, scrape a website and use that data to train an AI system. And that's why, I guess, in the future you want to make this specific, or like the lawmaker wants to make this specific, that this is possible. So I think that's a very different discussion than we are having in Europe, where we're not trying to find any specific solution like that, but are still thinking about what legal basis, what is the purpose, is it personal data or not. I also sympathized with your explanation of controllers and processors, and it doesn't really well match sometimes when you have an AI system that's extremely powerful. I think that's also something that we are struggling with, and we're gonna definitely look at Japan and see if they have maybe a solution that we don't have yet, because I don't think we have a good solution yet for how the concepts of controllers and processors match with just the reality of the grounds, the power imbalances, how much power big tech companies have in comparison to some of the controllers. And then to the AI bill, thank you very much, Akemi, also for being so very explicit that this is more of a symbolic thing, that it's trying to promote AI, but actually is not really doing very much. And I also find it fascinating how you describe the soft law versus hard law cultural approach, because indeed, whenever I look at Japanese law, I find it fascinating how on enforcement there's a lot of trust that just by the authority being kind of stern and issuing a statement saying something was wrong, that this would be the enforcement. Well, from a European angle, we always think we need fines, we need maybe more than fines, high fines, and there this could be enough. But I also, and we discussed this in our discussion before the session, there's now also doubts in Japan that maybe for some actors this does not work, because of course if you do not care what the public thinks about you, or if you're so big that you don't have to care, then this system is kind of put a bit in jeopardy. And that's, I think, also why the PPC wants their administrative fine powers, which I can very much understand. And then finally, maybe a question also for you, because you mentioned in the end the government using AI, and there's a lot of questions around that. So I think you should elaborate a bit more on these questions, because I'm very curious what they are thinking about doing, or also how transparent they are, because I mean now with the AI Act in Europe, we are hoping for more transparency. I'm not sure if we will get it, but I think also here we are actually on a similar journey. And then maybe a very, very last point, so this idea of law being a symbolic act, I think now the Commission has entered the phase of deregulation, but we're coming from a phase of very heavy regulation, and I think some of those laws maybe could also be described as a symbolic act, so I like that description very much. For example, the Data Governance Act, I'm still looking for the hard rules, but so just to say, also in Europe, we are playing around with different modes of regulation, and it's not all hard law for us either. But now I think I'll stop, and I don't know if you want to react or if we should go directly to the audience.
Okay, we'll have some reaction to Laura. And first, in data protection area, as she said, Japanese Act does not have the right to profiling or automated decision. But in 2020, in first Triennial Review, we expanded some kind of the right to delete. And it's not so enough, but it's similar to some kind of the right to stop profiling. And in some academic side, the important thing is the important point is the decision, and we have to see the point of decision in also the Japanese Act. It's the discussion in the academic area. And in the review of the adequacy decision from EU, the EU says the first triennial review is very good, and the expansion of the right to delete is very good for the expand to the Japanese adequacy decision to public area, but it's some kind of the so-called EU. Now the US is such kind of situation in data protection, and of course Russia or China is you see. So EU see Japan is one of the good partners. So I think the EU's review of the adequacy decision is highly political. So and of course transparency is not enough in Japan in comparison with Article 13 or 14 of GDPR, because how to take transparency information is the very problem for businesses. So also in second triennial review, I think the what kind of information must be transparent is the last problem for the statistical exemption and as a kind of legal basis for new act. Thank you.
So, Akemi, you have some comment?
Thank you, Laura, to comment on our issues. Then, especially for the why the Japanese hesitated making a law about AI is a little bit confusing, but not only the software approach, but for the where legitimate power and governmental side is highly connected in Japan. As I said, as we have a very strong political power with LDP, but I think especially for the transparency or legitimacy of the governments, we need the law itself. Then Japanese government explain about the AI bill is many people afraid the AI risk, and so we make a new law. Oh, it's very important, but actually we don't find out no binding powers. Maybe the Japanese government says that there is a binding power with specific areas. So we have to choose, or we have to informed by the business operator and the AI developers. Then we notify the risk and problems to the public. Then we make the sense with regulation as usual. So it is a very highly careful way of the Japanese regulation. I don't think it's enough, but this is a choice of the current situation.
So not only AI protection or information private, but also you say COVID, anti-COVID legislation or anti-COVID regulation.
Yeah.
Also, we have passed by.
Yeah, he will explain that. Why I say that my profile is I was in Mainz in Germany, because this was a Corona pandemic time. Then I also explained the Japanese colleagues and German colleagues to how different the European side and Japanese are. Is that this point? there is no binding power, but many people follow the government. This is a big difference from the situation. But as we discussed before the panels, not all companies in Japan follow the guidance. So that's why sometimes we are consider about consumer law. We have to debate on the differs from the companies who follow the guidance, who don't follow the guidance, the evil companies and so on. But sometimes the Japanese legal lawmaking process is confusing by the mix-up of the company's attitudes. Yuichiro usually said.
Yeah. So our panel presentation is over. From now, question time. It lasts 20 hours? 20 minutes? No, 20 hours. Too long. Yeah.
Okay.
So, anyone? Yes. First of all, it's ready.
こんばんは。Yokata Sensei, thank you for clarifying that it actually is a EI Promotion Act, because I was attending the STOA STS forum about the EU and Japan cooperation on the AI and quantum, and there were deputy and representatives from the government, from the ministry, from MIC and MEXT, and they were discussing about the Act and how it was under the valuation of the diet. And someone asked about if there were any guidelines about data ownership, and there was no, I guess there was no clear answer on that. So I wanted to know if you have any take about data ownership, or if there is going to be some, I don't know, guidelines adopted by the government when the issue is going to raise. Not that the E-Act in Europe is better developed on that side. Thank you.
Well, we also had some discussion about data ownership, but in legal, finally, we may don't need to the concept of data ownership, because in the data protection area, the regulation of our act or other data protection is only the regulation for the personal data, so we don't need any data ownership concept. And in intellectual property area, of course, we have some concept for ownership, but it's a concept of the act of copyright or act of patent. So the single concept of data ownership is not needed for the discussion. Maybe it's some kind of result of current situation.
Okay. And next is this gentleman.
This question is maybe for Akemi Yokota.
Thank you.
You already discussed the cultural difference in terms of soft law and hard law. And I recently visited Japan for months to do research on AI as well.
Oh.
And I think there are many cultural differences in how we view AI. I think there's much more positive attitude in Japan. What I found interesting in, you have the Children Museum in Japan, and they're all technology museum for kids of 5 or 10 years old, and it's about AI and quantum computing and facial recognition in a really positive way. And I think also I heard about like legal exemptions for training data in copyright, etc. Is it true that there's much more push from the government to promote that? And can you maybe explain why that is? Why is it a general feeling of positive attitude towards technology? Is it specific to AI? Thank you.
It's a very good question because you can imagine the manga culture in Japan, especially for the very traditional manga is called Doraemon, do you know? So he is a child care robot comes from the future. Then every Japanese knows the image of the Doraemon. Sometimes the child care robot have a mistake, it's very funny, but he is very friendly with the people. Then this image is very highly developed, highly trustful the Japanese user society. For example, in the restaurant, we also have a robot, servant for the moving the dishes and so on. Then this is a very basic attitude of the Japanese situation for not only for child care but for the old people and so on. But they also afraid that collecting data and move to the data to the board, then they also afraid that the other person mistakes of the use of the AI then spread some personal data information outside of the company or outside of the friendship areas and so on. So both sides is basically attitude of Japanese society, I think, but how do you think about?
Yeah, and I have some additional comment. In Japan, army is hidden from our society. So, for example, drone is some kind of weapon. But in Japan, drone is not weapon, so they have some job to take some medicine to the highly apartment, and they don't drop some bombs. It's a very rare situation in Japan. Of course, we have some self-defense forces, but it's some kind of taboo in the society. So we don't have, in many situations, we don't have discussion about army. So the first concept for robot is not the weapons for Japanese people, as Akemi says. It's Doraemon or the very friendly robot. So in Japan, there are many companion robots to order some goods for the robot. And we don't imagine Terminator or the fighting robot for robots. So it's a very cultural difference with the ordinary country that have usual armies there, I think.
Oh,
Thank you very much for your contributions. It's been very insightful. My question is for Akemi Yokota, but any speaker can react if you would have insights to share. I was wondering about the fifth point in the table that we have seen. It was regarding appropriate procurement and use of AI in the public sector. And specifically, I would be curious to know if a procurement strategy has changed in light of technological developments, if there are certain points regarding data or model ownership or data protection related developments in this field. If you would have any insights to share, or if there have been any developments, maybe the answer is no, but I would be curious to know.
Oh, what you want to mean the strategy inside of the government to use, or well?
I was curious about the procurement of AI technologies in the public sector.
Okay.
Mainly procurement
I
strategy.
see. It's very important point because as I showed the conceptual image, so they are focused on these problems because AI model, not only AI model, but also for the computer and technology and so on, we have many problems with how to get module, the government, how to get module as safety and what to say, well, with know-how, but we have to consider about the equality of the how to decide from whom to buy. Then this AI strategy also has this point shows that we have to consider more agile things to be agile and so on, but I think it's not so big issues inside of Japanese society nowadays. But we have to consider not only AI problem, but for the cloud, government cloud problem and so on. Then we have to consider about. But I don't have a clear image about this problem. Sorry, but this. AI strategy document also has this kind of information.
Yeah, the procurement problem is a great problem, especially in small local government. If they want to use AI or generative AI, they just use, they just come into terms of use of and they can't check the complicated contract, and they can't negotiate with OpenAI directly. So, as you said, the procurement is a great problem. Sometimes we have some discussion in local government AI related meeting. Akemi and I are also a member of MIC here.
Laura, do you have some comment?
Well, I don't know much about Japanese procurement either, but indeed, I think it's something that maybe also in the EU we need to be more aware of. That, I mean, this is a big step now. The tools that the government is using, and not just AI tools, all their tools, I think we should be stricter there what we allow, because if it's a tool that cannot comply with our laws, like data protection law or AI regulation that we now also have, then I feel the government should be the first one to say we cannot use this, because in the end, maybe they have, if they go together, some powers to negotiate. And I know there are Dutch colleagues here, but I know in the Netherlands they are sometimes a bit better at doing this and like at pulling some public authorities together and trying to get some better terms and conditions. But it's definitely also a problem on European side, and a topic that deserves more attention. So I hope there's some research forthcoming from our colleague there.
Yeah. Okay, next, please.
Hi, thank you so much. I'm Claudia, I'm from the University of Luxembourg, and I'm a computer scientist, so I really appreciated this talk. I learned a lot. So first, apologies if there are misconceptions on my question, because this is not really my area, but I have certain colleagues who say there's a big difference between Brussels effect, European standards, or APEC standards, let it be on data protection, or I think even the APEC just recently released some AI guidelines. And I wanted to know if you've seen any of this conflict when you're doing regulation there in Japan, as like maybe the APEC has a lower standard on some aspects, and if you've seen some conflicts with any Brussels effect happening in Japan. Thank you.
Please.
Okay, so maybe this is a question where I know something about. So indeed, the APEC CPPR standard is lower than what, for example, the GDPR wants if it comes to data transfers. And this is actually something, so the Japanese adequacy decision was reviewed in 2024, I think. or 2023, so recently, and that's actually one of the few more critical points that the Commission raised in there, and namely that there is EPIC CPPR, but it is not going to work from a European perspective because the standard is lower. If you look at the EPIC privacy principles, they're very similar to what we have from the OECD, so very high level, very abstract. And what we, for example, created with Japan in the adequacy decision is much more detailed and protective. But I think, and that's something I find so fascinating about Japan, they have different transfer rules when it comes now to transfers for different countries. So they have for the EU the adequacy decision, but for other countries, they do rely on the EPIC framework because their system is flexible to accommodate kind of both worlds.
Yeah. I was one of the drafter of CBPR, so I have some responsibility. Yeah. The conflict between CBPR and European concept is the problem over 20 years. And these days, Japan and APEC and other area has developed a global CBPR, and UK joined CPPR, so that's the second conflict point of CPPR and EU-like concept. But actually, in Asian countries, in some Asian countries, there are no data protection act or privacy commissioner, so some kind of the data flow between Asian area, we have to have some certification system. So the CBPR is our some struggle for the data flow in Asia, but not so many number of businesses certified in CBPR. So our other expansion of CBPR is global CBPR, but it seems it's just the start of the certification system, and the criterion is as same as APEC CBPR. So maybe Brussels doesn't like also global CBPR. So I have some responsibility for these two certification systems. Yeah. Sorry for that.
This panel is very independent panel, so, but his history is it's kind of the Japanese data flows international history as well. Okay.
Yeah, but yeah.
Thank you for this panel. I have a question on proposed AI law, Japanese AI law. So, there is no direct penalty provisions. The provision or the strategy Japan has taken is naming and shaming, because reputation is a very huge thing in Japanese culture. So, do you think it's going to be effective in forcing AI companies to respect users' rights?
It's a very good point.
And just one more thing, like if you could give one example where this reputation thing has worked in past, like because of the reputation, companies were trying to follow the law. Or
Maybe this is better for the Yoichiro maybe explain about some. But the PPC has sometimes make official orders, but usually don't use the powers. Mm-hmm.
Yeah, they have some recommendation to the big techs in US, and so they don't have order to big techs or AI providers, but they often have some discussion with such companies because they have some business in Japan, and they have business between Japanese government. So the Japanese government or PPC says it's effective, but we can't check such kind of unofficial discussions. So, but so I think sometimes the U.S. agency or EU privacy commissioners firstly have some order or so, and Japan combine its Japan is on their orders or civil penalty. Yeah, I think.
So this is kind of the issues of the data protection. PPC has a legal binding power, but they don't use. But I'm afraid that the AI law is not connected to any binding powers. So that's why I'm afraid that this difference makes different result. I'm afraid about it. But I think this is not so bad because connection with other regulation, then comparison with other regulation situation is very important. It's very easy to understand. Okay, but
All right.
all right, I wrap it. So, but this is unclear situation. Then your opinion is very important.
Maybe to just add, if you read the review of the Japanese adequate decision by the European Commission, they list a couple of cases where they said the PPC's powers have worked. So then you can look up those. But that's, of course, for data protection or nothing for AI specific.
So unfortunately, she said 2 minutes, but my what she called me stopped now. So this is a Japanese legislation situation. Do you have any impression? Please react by in line. She has they have an email address, perhaps. So thank you very much.
Thank you for joining.